Government Business Notice Number 1, standing in the name of Ms Boothby to present the Attorney-General Legislation Amendment Bill 2025, Serial 19.
Attorney-General.
Madam Speaker, I present a bill titled the Attorney-General Legislation Amendment Bill 2025, Serial 19, and table the explanatory statement. Madam Speaker, I move the bill be read a first time. The purpose of this bill is to make a number of minor amendments to various pieces of legislation within my portfolio. Individually, these amendments are not extensive enough to warrant their own amendment bill, but are nevertheless required to ensure the legislation is up to date and correct. The purpose of the bill is to enhance efficiencies across a range of legislation and across the legal landscape. An omnibus bill of this nature promotes efficiencies because it allows for a lot of amendments to be made at the same time, quickly and effectively. The first amendment is to the Healthcare Decision-Making Act 2023 to allow for the senior practitioner to delegate their functions and powers to a public sector employee who has the necessary qualifications and experience to carry out those functions. The senior practitioner is a statutory appointment of a single person, and it is physically impractical for that single person to attend to all requests for the use of restrictive practices. This amendment will enable the senior practitioner to delegate their powers and functions to appropriate staff to ensure timely and appropriate care of persons with impaired decision-making capacity. Secondly, the bill amends both the Justices of the Peace Act 1991 and Oaths, Affidavits and Declarations Act 2010. These amendments will ensure current practices of obtaining a national police check for persons appointed as a Justice of the Peace or Commissioner for Oaths in the Northern Territory. The current practice ensures that only people who are fit and proper are appointed following a criminal history check, and these amendments enshrine that high standard in the legislation. Thirdly, the bill amends the Land Title Act 2000 to accommodate the transition to e-conveyancing practices in the Northern Territory. The amendment will allow for the Registrar-General to exercise discretion around issuing paper certificates of titles in certain circumstances, noting that e-conveyancing will modernise the process and dispense with the need for the Registrar-General to issue paper titles. Fourthly, the bill amends the Legal Profession Act 2006 to exclude the application of Section 57 of the Interpretation Act 1978, removing the requirement for numbered subordinate legislation to apply to the Australian Solicitor Conduct Rules. This means it will allow for the Law Society of the Northern Territory to adopt, with approval from the Attorney-General, the Australian Solicitor Conduct Rules, which would bring the NT in line with other Australian jurisdictions and without the need for the Office of the Parliamentary Counsel to draft the rules. The bill also amends the Misuse of Drugs Act 1990 to prescribe fentanyl and its analogues and nitazines and its derivatives as Schedule 1 dangerous drugs. Fentanyl and its analogues and nitazines and its derivatives have a higher risk of overdose compared to heroin, which is a Schedule 1 dangerous drug, and the illegal sale of fentanyl has been increasingly internationally within the heroin market, with NT Police also encountering more illicit substances where fentanyl is present. The bill further amends the Northern Territory Civil and Administrative Tribunal Act 2014 to further clarify that the Territory Civil and Administrative Tribunal, or NTCAT, may make cost orders for recovery of any fee required by the Act, or for serving documents or conducting a search by a successful party. The intent of this amendment is to make it abundantly clear that a successful party is entitled to recover its costs associated with filing and serving documents required under the Act, and other costs associated with those processes, such as name or address search. This reflects the base position that a successful party should not be penalised for exerting their basic legal rights. However, in keeping with the otherwise general position that the NT-CAT is a no-cost forum, other costs, such as lawyer fees, will remain subject to formal consideration and decision-making by the NT-CAT. The bill also amends the Northern Territory Civil and Administrative Tribunal Regulations 2014 to provide that there is no fee associated with an application under the Health Care Decision Making Act 2023. The regulations currently provides that there is no fee associated with an application under the Guardian of Adults Act 2016 or the Advanced Personal Planning Act 2013. This amendment will ensure consistency across decision-making applications for vulnerable people. The bill then amends the Residential Tenancies Act 1999 to include sections 18A, applying for a tenancy, and section 18B, keeping of tenant information, as exemptions for tenancies under the Housing Act pursuant to section 7, subsection 5. This amendment also clarifies that payments from the Agents Licensing Fidelity Fund for administration of the Act and educational purposes can be made to the Commissioner of Tenancies, landlord representative bodies and tenant representative bodies, or any combination of these. Lastly, the bill amends the Sentencing Act 1995 to expressly allow for a home detention condition to apply to part of the period of an intensive community corrections order. While home detention conditions were intended to be an option for courts to impose as part of an intensive community corrections order, the ability to do so has been interpreted as an all or nothing option. The proposed amendment will make it clear that a community corrections order can contain a home detention condition that only applies for a portion of the duration of the community correction order, and it clarifies when fixed non-parole periods apply to correct limitations on the setting of minimum non-parole periods unintentionally established by the Sentencing and Other Legislation Amendment Act 2022. I'm pleased to commend this bill to honourable members.
The question is that the bill be read a first time. Those of that opinion say aye. To the contrary, no. I think the ayes have it. The clerk.
A bill for an act to amend legislation administered by the Attorney-General.
Attorney-General.
Madam Speaker, I move that the bill be referred to the Legislative Scrutiny Committee for report by Wednesday the 30th of April 2025.
The question is that the motion be agreed to. Those of that opinion say aye. To the contrary, no. I think the ayes have it. The clerk will read